All right, we'll go ahead and get started here. So as per usual, got to do some disclaimers. So the views that I'm going to discuss and provide today are mine and mine alone, in terms of them not representing the official views, ideas, or attitudes of the Air Force, the Space Force, Department of Defense, or the United States government. I've only used open source information available to the public in researching and presenting this work. All right, so what we'll do is, what I want to do is just give you right up front my argument, and then some background on why I think this is important, and a kind of a case study that illustrates some of the things I'll deep dive and discuss further. Then we'll talk about liability for damage and really the three liability theories. Then we'll go into some of the responsibilities for space-related activities. And then I'm going to take a little aside and talk about autonomous systems as well as artificial intelligence and how they fit in with state responsibilities, and then some practical considerations that are important for that, or rather important for those. And then I'll put it, or at least try to put it all together with a framework to analyze fault-based liability. And then we'll just highlight some major implications and then see if there's any questions. So let me go ahead and set the scene for my argument and provide the conclusion up front. One of the natural consequences of increased space activity and space becoming increasingly congested is that there's a greater risk for collisions. In 2019, the European Space Agency had to maneuver an ESA satellite to avoid a collision with a cluster of small satellites that were operated by SpaceX. The ESA's satellite was equipped with an anti-collision device, but the device was not activated. Fortunately, inadequate supervision and control allowed ESA to fire the satellite's thrusters, which increased its altitude and avoided a collision. So this instance of successfully performing an emergency maneuver to avoid a collision with active satellites was a first for ESA, but it won't be a last. ESA also noted that the maneuver was a time-consuming operation that will not be possible as additional man-made objects enter space. And so we start looking then, and we see that responsibility for space activity is not a new concern for the international community. It actually was considered shortly after the space age began. In 1963, the United Nations Declaration of Legal Principles governing the activities of states in the exploration and use of outer space, it included some provisions about both state responsibility and liability. The declaration noted that a state is internationally responsible for national activities in outer space that are carried on by the state's government or non-government entities. In addition to that, the declaration noted that every state launching or procuring the launch of a space object, or from whose territory or facility a space object is launched, would be internationally liable for damage caused by such objects. But how such liability would be established was left unexplained. And that's leaving key terms undefined is kind of a theme that we see in the relevant treaties that followed. In 1967, you end up getting what we typically call the Outer Space Treaty, which has the long name of Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, but I'm going to just refer to it as the Outer Space Treaty for the rest of this presentation. And it provided the basis for international space law. The principles regarding state responsibility, liability, and obligations to authorize and provide continuing supervision from the 1963 Declaration were incorporated into the 1967 Outer Space Treaty, with only minor changes in wording. Although the Outer Space Treaty expanded on the Declaration, a lot of the key terms were again left undefined. So similar, a standard to assign liability was also not provided. So then we get the Convention on International Liability for Damage Caused by Space Objects. We're going to call it the Liability Convention today. That came in 1972. The Liability Convention provided a regime of absolute liability for damage that's caused by space objects on the surface of the Earth or to aircraft in flight, and then for damage caused by space objects to another state's space objects or persons or property on such space objects. And those limits will be highlighted as why they're important in a little bit. And that Liability Convention established a fault-based liability regime. So what exactly constitutes fault was left unclear, and we still have questions today about that issue. So as space activity continues to increase, states and non-government entities alike should have a better understanding of fault-based standards. During my research, I found that general principles of international law could be used to provide clarity, including a practical approach to fault-based liability. So that brings me to my argument, which is essentially that when a state fails to meet its international obligations, such as its fundamental duties of authorizing and supervising non-governmental entities' space activity, if the state knows or should know that the obligation has been triggered, then such a failure constitutes an internationally wrongful act and thereby establishes fault of the responsible state. All right, so let's get into liability theories. And I've really come across three main ones, at least for the through an international realm. So if a state's natural or a juridical person suffers damage from another state's space object, then they might seek or they might attempt to establish liability in one of these three ways. Now, my focus is on fault-based liability, which is only explicitly mentioned in the Liability Convention, but I'm going to discuss the other theories for context and because fault-based liability may apply in the other theories too, as I'll explain more. It's also important to note at the outset that while responsibility and liability in international space law overlap, the two are not attributed based on the same criteria. So states are responsible for their national activities in outer space pursuant to Article 6 of the Outer Space Treaty, but liability is imposed on launching states through Article 7 of the Outer Space Treaty and then the Liability Convention. Another key consideration to remember is that the type of damage suffered, what is damaged, and where the damage occurs can drive different requirements for proof. So this means that a wrongful act may be required in some circumstances, but in other contexts, causing damage alone will trigger liability. All right, so let's look at state responsibility first, that theory. Now, in general international law, states are responsible for internationally wrongful acts or omissions if they're attributable to the state. An internationally wrongful act must constitute a breach of the state's international obligation, and the act or omission must be attributable to the state. An international obligation is breached when an act of the state fails to conform with what is required of the state by the obligation. And that's regardless of the obligation's origin or character. So obligations can arise from a treaty, a rule of customary international law, or even a general principle applicable within the international legal order. And the general rule is essentially that only conduct attributed to the state at the international level is that of its organs of government or of others who've acted under the direction, instigation, or control of those organs. So, for example, agents of the state. Now, Article 6 of the Outer Space Treaty contains two fundamental international obligations. These obligations are for states to authorize and to provide continuing supervision of the state activities of their non-governmental entities. And those obligations apply to state parties to the treaty, and the obligations may also apply to states who are not parties as a matter of customary international law. And I think there's approximately 130 or 130 plus states that are party to the Outer Space Treaty, but still, there are still certainly some states who are not and who may be obligated by customary international law. So Article 6 reverses the general rule in international law that states usually are not responsible for actions of their private citizens not acting under the direction or control of states. According to Article 6, state parties bear international responsibility for the national activities in outer space, including the moon and on other celestial bodies, whether such activities are carried on by government agencies or by non-governmental entities. And that's quoting that part of Article 6. So what exactly constitutes a national activity? Well, it's not clarified in the Outer Space Treaty. However, Article 6 of the treaty does make clear that states bear responsibility in outer space for actions of their private actors, meaning that the space activities of non-governmental entities are attributable to the state. Further, after the English version of the Outer Space Treaty notes responsibility for national activities in Article 6, it then specifies in Article 7 that a state is liable for damage caused by space objects when the state is a launching state of that space object. So in terms of a standard, a mere accident would not likely suffice for liability in the state responsibility theory. Absolute liability is the exception. It's not the rule in international law, but an argument could be made that space activities are ultra-hazardous activities for which absolute liability is appropriate under certain circumstances. I think more likely the standard, whether absolute liability or some degree of fault, would depend on where the damage occurred and what was damaged. So if the damage occurred on the surface of the Earth or to aircraft in flight, the standard may likely be absolute liability, while damage between space objects or damage occurring in space would probably be fault-based. The probable standard for damage on the surface of the Earth and to aircraft in flight reflects the principle that an actor creating circumstances with the possibility of acute and catastrophic danger is liable without proof of fault to pay compensation if that danger eventuates. Similarly, the probable standard requiring some degree of fault, but not necessarily absolute liability for damages occurring among space objects or elsewhere than the Earth's surface, it really reflects the idea of sharing risks among those engaged in space activities. So a harm state may use the state responsibility theory for a couple of reasons. One is that it might be more advantageous or even the only option in certain circumstances. One advantage includes not having a limited scope of compensable damages. So Article 1 of the Liability Convention defines damage to mean the loss of life, personal injury, or other impairment of health, or loss of or damage to property. So if a harm state incurs, let's say, electronic interference or or indirect, consequential, and loss of revenue types of damage, that damage probably is excluded from the Liability Convention. And it's also important to note that under the liability provisions of both the Outer Space Treaty and the Liability Convention, only states that meet the definition of a launching state can be liable. So another practical reason why a state might consider the state responsibility theory is a case of a private actor from a non-launching state purchasing or otherwise acquiring a space object, such as a satellite, from a launching state and taking over all the operation and control of the satellite. If the satellite subsequently were to cause damage to the harmed state may wish to pursue a claim against the acquirer state, arguing that the acquirer state is a quote-unquote responsible state under Article 6 of the Outer Space Treaty for its non-governmental entities' activities in outer space. So even though the launching state remains liable for damage caused by the satellite pursuant to both the Outer Space Treaty and the Liability Convention, the harmed state could seek to recover from the, again, quote, air quotes, responsible state that does not meet the Outer Space Treaty and Liability Convention requirements that a liable party must be a launching state. So the state responsibility theory, it may also be a more attractive option if the responsible state has deep pockets and the launching state does not. There's a couple different practical reasons that could be considered. All right, let's look at the Liability Convention. So the second method of recovery comes from, actually, let's look at the Outer Space Treaty first. And that's where the second method of recovery comes from. And as I mentioned, the Article 6 renders a state responsible for the national activities in outer space of its government entities, non-government entities, and also its international organizations in which the state participates. Article 6 also places the responsibility to authorize and provide continuing supervision for space activities of non-governmental entities. And then Article 7 is the one that discusses liability. But Article 7 doesn't define damages, which means that the scope of damages under Article 7 of the Outer Space Treaty may actually be broader than the scope of the damages in the Liability Convention. There are some other issues with Article 7. So specifically, what is the standard for liability? Is it absolute liability? Is it some degree of fault? It's silent on that. So does the standard differ for damage caused in outer space, in airspace, or on the surface of the Earth? Those aren't clear from the text. It's also unclear whether Article 7 applies to objects that fail to reach outer space and how liability is supposed to be shared when more than one launching state's liable for the damage or for damage. Some scholars have defined that absolute liability is the standard and base that on customary international law, applying absolute liability for damage caused by space objects to third parties on the Earth's surface and to their aircraft in flight. And that assumption also aligns with the 1952 Rome Convention on damage caused by foreign aircraft to third parties on the surface. But it's questionable whether the assumption of absolute liability actually would apply to collisions between space objects, regardless of where the collision occurs. Despite all these, some of these assumptions, doubt really remains as to whether the article implies fault or no fault liability. The Liability Convention's distinction between absolute and fault-based liability, depending on where damage is caused, and the general international consensus when establishing the related articles in the Liability Convention, further support that fault-based liability may be the applicable standard under Article 6 of the Outer Space Treaty for damage not caused on the Earth's surface or to aircraft in flight. All right, let's look at the Liability Convention now. So, a few years later, in 1972, the Liability Convention adds some clarity. It gives some definitions of damage and space objects, and it also clarifies that a launch includes an attempted launch. Notably, because the Liability Convention is more recent in time than the Outer Space Treaty and specific to the issue of liability, It's the applicable treaty and regime for liability claims amongst parties to the treaty. And Article 2 of the Liability Convention imposes absolute liability for damage caused by space objects on the surface of the Earth or to aircraft in flight. So we get a clear legal standard from Article 2. It's notable that the legal subcommittee of the United Nations Committee on the Peaceful Use of Outer Space, or UNCOPIUS, did not encounter any kind of significant opposition to agreement on the absolute liability provisions in the Liability Convention. And this likely reflects that the standard already had international support and what the standard would be under similar circumstances for non-state parties to the Liability Convention. And that's kind of plugs back into what why I was saying it's likely that that would be a standard for similar damage under the Outer Space Treaty. Now, Article 3 of the Liability Convention provides a fault-based liability standard for damage that's caused by a space object to another state's space object or to the persons or property on board another launching state space object elsewhere than on the surface of the Earth. So the state would be at fault if the damage is due to its fault or the fault of persons for whom it's responsible. Notably, Article 3 of the Liability Convention applies fault-based liability in both airspace and outer space if the damage is caused by a launching state space object to another launching state space object or to persons or property on board the other state's space object. The convention does fail to elaborate further on elements needed to prove liability, especially as to what constitutes fault. Similar to absolute liability provision, the agreement in principle on Article 3 did not encounter any kind of significant difficulty, suggesting that there was probably international, if not consensus, at least a large degree of support. Judge Manfred Locke's actually reasoned that the rationale for fault-based liability is that once space objects are launched, all launching states may be presumed to have taken similar risks. Now, the rationale that states engaging in space activities should be liable for damages to each other in a fault-based regime and absolutely liable to states not engaged in space activities or suffering damage on the Earth's surface or to their aircraft in flight is also informative and reasonable for liability considerations under either of the other theories that I mentioned. So Article 3 of the Liability Convention does have two potential meanings. One, it may mean that a launching state's liable only to the extent of its fault. And alternatively, it could also mean that a state becomes liable for the totality of the damage as soon as it has been established that there is fault on its part and that there's a causal connection between the fault and the damage. Regardless of whichever meaning is correct, fault must be proven. But unfortunately, fault's just not clarified in the convention. Now, on the bright side, though, the convention did contemplate more than one state being liable for damages caused by space activities. In Article 6 of the Liability Convention, it allows a claimant state to hold a launching state or states jointly or severally, jointly or severally liable for the damages. Such liability remains absolute for damage caused on the surface of the Earth, of course, or to aircraft in flight. So for damage caused elsewhere, where it's based in fault, what you end up getting for either of those is the burden of compensation for damage is apportioned between launching states to the extent to which they were at fault. But if you can't get or show clearly the extent to which state or states are at fault, then the burden is apportioned equally. But again, there's more discussion about fault, and fault's not further clarified or defined. Regardless of which avenue that a harmed state pursues to recover for damage suffered by its natural or its juridical persons, if the damage occurs elsewhere than the surface of the Earth or to aircraft in flight, fault-based liability is likely going to be applied, and a wrongful act will need to be proven for liability to attach to the responsible state or states. All right. So now that we've kind of gone through the theories of liability, let's look at some of the responsibilities, and certainly there are a lot, but I'm going to highlight a few. We'll talk about authorization first. So Article 6 of the Outer Space Treaty obligates its numerous state parties to authorize non-governmental entities' space activities. But it's kind of interesting there because several of the Outer Space Treaty's obligations likely apply to all states because of the obligations crystallizing into rules of customary international law. So when it comes to non-state parties to the treaty, it's likely that they have the same obligations. And this is reflected in the writings of a number of highly qualified publicists. So when I'm talking about these obligations, I'm really contemplating that they're applying universally. I'm not aware of any persistent objectors. The responsibility of states for the activities of its non-governmental entities reflects a compromise between the Soviet Union and the United States when the treaty was negotiated. The Soviet Union at that time wanted to forbid private activities in outer space, and the United States wanted to allow for such activities. So the two states ended up agreeing that private activities in outer space would be allowed, but responsibility for those activities would be placed on states. So what's the importance of this one? Well, authorization represents a critical opportunity really for states to be able to ensure that appropriate conditions are met and evaluate risk before allowing a space object to be launched. The authorization process also provides an opportunity to minimize the risk for damage and for adequate consideration of relevant factors for new and emerging technology prior to engaging in space activities. So some of the relevant considerations should include things like safety, public order, protection of the environment, international obligations, policy interests of the respective states, as well as whether the entity has adequate insurance. Continuing with the kind of the theme of issues left open to interpretation, the Outer Space Treaty and its progeny do not clarify the depth of the obligation to authorize or how it should be carried out. The OST, or the Outer Space Treaty, does not require national legislation to comply with the authorization responsibility, but there are plenty of good reasons to have relevant domestic legislation. The legal subcommittee of UN COPIUS established a working group on the topic of national legislation relevant for peaceful exploration and use of outer space. And that group determined that its final report should essentially provide a basis for recommendations on national space legislation. So consensus on their recommendations was reached, and the recommendations ended up including 8 elements for states to consider when enacting national space legislation. Included in the elements is the authorization procedure and also conditions for authorization. So the national legislation of a number of states, including major spacefaring states like the United States, Russia, and China, all contain conditions for authorization of space activities. And similarly, the International Law Association's Committee on Space Law began work on a model law in 2008. It was related to the commercialization of outer space, and that committee essentially used its quote unquote building blocks, or what are known as its building blocks from its 2004 work. And those building blocks end up being considered as essential cornerstones of future space legislation in view of the international law obligations of states stemming from Outer Space Treaty and the Liability Convention. These building blocks included authorization of space activities, among 4 other key components. And based on these building blocks, a model law was ultimately completed with 14 articles, and that included articles on authorization and conditions for authorization. So the committee also provided comments that indicated what responsible authorization entails. And prior to authorization, basically an applicant should establish a secure financial position as well. Additional requirements include foreign policy, national security, public safety, international telecommunication regulations, and insurance all being fulfilled. So they've already really provided this framework and a lot of considerations. And the committee's work is now known as the SOFIA guidelines for a model law on national space legislation. Now, even though there's no international obligation requiring states to have national space legislation, you kind of have to consider that based on international requirements and state practice demonstrating a need for national legislation, that if you don't have it, it makes it suspect as to whether proper due diligence and adequate authorization is really occurring in the absence of some kind of established legislation or at least similar administrative regulations. All right, continuing supervision. So like the responsibility for authorization, continuing supervision is likely crystallized into a rule of customary international law too, and it's likely applicable then to states that are not party to the Outer Space Treaty. So the obligation is likely universally applicable to all. And again, the Outer Space Treaty provides neither further detail regarding how the duty is to be executed, nor requires national legislation related to continuing supervision. But again, state practice and prudence suggest the necessity for national legislation relating to continuing supervision. Again, UN COPIUS's legal subcommittee's recommendations for national space legislation also included ways and means of supervision of space activities as an element. And also the ILA Committee on Space Law's SOFIA guidelines included similar information related to continuing supervision. Specifically, it noted that continuing supervision should be conducted according to an implementing decree or regulation, and that supervision is part of numerous states' national space legislation was noted. And again, I noted that that includes major spacefaring states like the United States, Russia, and China. In terms of considerations for compliance, responsible continuing supervision should probably ensure that the underlying conditions for authorization continue to be met during and after when space activities are conducted. So continuing supervision would provide what? Well, it provides states with an opportunity to minimize risk for damage, ensure compliance with international obligations, and also make sure that appropriate conditions are met for space activities. That initial authorization also goes hand in hand with continuing supervision. Relevant national legislation regulations really help ensure compliance with the international obligations, the responsible use of outer space, and that those involved in space activities are, as some scholars have stated, technically, financially, and operationally fit and have proper compliance disposition with relevant law. All right, one other note, who is the appropriate state? We've identified international obligations, but who's responsible for really upholding those obligations? Well, Article 6 of the Outer Space Treaty places responsibility for authorization and continuing supervision of their non-governmental entities in outer space on, and I'm quoting, the appropriate state, singular state, party to the treaty, end quote. So assuming Article 6 of the Outer Space Treaty has crystallized into a rule of customary international law, same responsibilities again are going to exist on non-state parties too. But unfortunately, treaty again is silent regarding who the appropriate state is, or states, plural. The lack of clarity has led to a number of theories. So one theory is that the appropriate state is a launching state. Article 7 of the Outer Space Treaty, consistent with other major space treaties, including Article 1C of the Liability Convention, contemplates the possibility of multiple states being defined as a launching state and thereby being subject to liability for damages caused by their space objects. So some scholars have argued that the appropriate state should be a launching state because Article 7 places liability on launching states. But by defining the appropriate state as a launching state, that raises the problem of what to do when there are multiple launching states, despite the singular use of the word state in Article 6. Now, another theory is that the appropriate state is a state of registry. So Article 8 of the Outer Space Treaty ensures jurisdiction and control over a space object and its personnel, if any, are retained by the state of registry. But notably, there can only be one state of registry, which must also be a launching state. So some scholars argue that the state of registry is the appropriate state in Article 6 because the state of registry retains jurisdiction and control of the space object and its personnel. But there's also flaws with the state of registry approach. First, if responsibility for Article 6 obligations rests solely on the state of registration when the other launching states exist for a space object, then the other launching states would not have any international responsibility for the space activities of their non-governmental entities. And that result seems contrary to Article 6's intent. Second major issue is that states may choose a poorer state for registration to mitigate their own financial liability. A little bit of gamesmanship, basically. So using state of registry to determine the appropriate state for Article 6 obligations could ultimately incentivize a registry of convenience. Launching state and the state of registry concepts also share another major disadvantage, and that's that the launching state designation can't be shed at a later time. So modern times where space objects are bought and sold in orbit on a regular basis, which was not envisioned by the drafters of the Outer Space Treaty, if a transfer of a space object divests an original launching state from any practical interest in a space object, it's illogical that the original launching state should maintain the obligations of authorization and continuing supervision. The obligations should belong to a state whose non-governmental entity the space object was transferred to and is controlling that space object and certainly probably enjoying any kind of benefits from it. Bin Chang also made a practical argument that the singular terms or term used does not actually preclude a plurality of appropriate states. He essentially argued that every state that may be held responsible for Article 6 or 7 of the Outer Space Treaty should be entitled or even under a duty to subject its national activities in space to its authorization and continuing supervision. and thereby making each state an appropriate state. So in one scenario, if you have state A, whose national could procure the launching of a space object in state B, unbeknownst to state A, and if state B is not, say, a mature or responsible state, then such actions could actually still place responsibility for through Article 6 of the Outer Space Treaty obligation on state A, even though state A was wholly unaware of the actions based on no fault of his own. Essentially, it places responsibility on state A, even though it technically is responsible for the Article 6 Outer Space Treaty obligations related to its national space activity. It just doesn't make a whole lot of sense when state B could be a second appropriate state, and thereby the state that should be held internationally responsible for failing to meet international obligations related to space activity that state A's national procured in state B. So we'll get away from space math and let's go back to transfers for a minute. And nothing prohibits a relevant states from agreeing which state or states will authorize and provide supervision for their certain space activities. But any state concluding such an agreement should remember that regardless of the agreement and its provisions, states cannot delegate their responsibility and liability from the Outer Space Treaty or the Liability Convention. So then you get this saying, once a launching state, always a liable one. All right, let's go over to technology for a minute. Let's talk autonomous systems, artificial intelligence, and some component parts. So we got the theories of liability, we got some state responsibilities. How does technology play into this? Well, certainly computer technology has played a major role in human spacefaring activity, and it's critical to a massive global space economy that continues to grow. With increased space activity, we should naturally expect there's going to be additional space objects to include more autonomous operating systems and artificial intelligence, and I think that's really because these technologies offer increased capabilities and safety mechanisms. Now, the technical complexity of the systems tends to grow in tandem with the system's autonomy, and that tends to shift more decisions and actions from human operations to the systems themselves. As such, states, or at least the appropriate state for each space object, will be internationally responsible to ensure authorization and continuing supervision of more non-governmental space activities with AI and autonomous systems. So let's kind of get into a few of the details. We're certainly not going to go into a detailed history of automation, autonomous systems, and AI. That's well beyond our scope and would need hours. But let's get at least some basics, and then I'll kind of plug it all together. So for our purposes, conventional automatic systems generally perform one repetitive task. On the other hand, if you have and I should say automatic systems, excuse me. So your automatic systems, they really just kind of perform one repetitive task. Autonomous systems, on the other hand, they can react to external stimuli. They can also decide how best to react. And then you go to the artificial intelligence, and there's no universally accepted definition. There's a number of proffered ones. One that I think is helpful comes from Niels Nielsen, and it's the definition is that artificial intelligence is that activity devoted to making machines intelligent, and intelligence is that quality that enables an entity to function appropriately and with foresight in its environment. So AI also includes things like just a number of subfields: machine learning, increasing capacity for machines to exhibit intelligent behavior. It can include all kinds of different really subfields, but another way to think of AI is think of it as algorithms, and these algorithms are part of an evaluation process within a system that helps the system process stimuli, including learning from experience, and then output a decision or a reaction. These algorithms are essentially step-by-step instructions for a computer to follow. When algorithms are chained together, now we have a product called AI. And these AI algorithms have two important considerations. The first one is that these algorithms typically deal with probability. Probability is a key, and it's not certainty. The second consideration is that the role of the programmer related to the algorithms. For traditional algorithms, you've got a programmer telling the algorithm what instructions to follow. But in AI, programmer doesn't tell the algorithm what to do through pre-programmed instructions. Instead, the programmer tells the algorithm how to train itself what to do. And to make such a determination, the AI algorithm will rely on data and the rules of probability. And then the last important consideration for autonomous systems is rationality. So a system is basically rational if it does the right thing. To do the right thing, the system needs to be programmed to know what the right thing to do is, and then how to make such an assessment. To act rationally, a system needs parameters and criteria to assess its expected outcomes for potential actions, and these criteria are going to be called performance measures. So this means that a rational system will use its built-in knowledge and experience it's gathered to select an action that allows it to be most successful in light of its performance measures. All right, so uh, with that basic background on automation, autonomous systems, and AI, let's look at some of the considerations for states to adequately fulfill their international obligations. Some scholars have noted importance of real-time monitoring for anomaly detection. And for AI in particular, adequate monitoring consists of reviewing data points and then identifying the points that don't match the normal pattern. To adequately do this, you need to understand what is expected on average and then also normal variability around the average. It's not a hard concept. This is something that sports teams, race car teams, banks, governments, amongst others, do on a daily basis. The key is that there is some reliable understanding of what the expected average is, and then also an understanding of variability around the average. So a book called Life 3.0, the author Max Tegmark notes a number of lessons learned from various sectors, and I really thought it was telling that a number of these were directly space related. So I'm going to talk about 4 of those lessons that are pertinent to this discussion. The first is verification. So verification that a system is built right is critical. Verification is a process of ensuring software completely satisfies all required expectations of it, and it should also be thoroughly completed. Verification is the way where you catch bugs in software and avoid preventable mishaps. Even simple software glitches for space activities can have catastrophic results. So a couple examples. European Space Agency's Ariane 5 rocket 96 and NASA's Mariner 1 mission to Venus exploded shortly after the launch because of faulty software. The Mariner 1, the problem was as simple as an incorrect punctuation mark in the software. It was an exclamation point. So another example, NASA's Mars Climate Orbiter accidentally veering into Mars atmosphere and then burning up due to the software error, which affected its rocket engine thrust control. So with these examples, we see verification. For verification, software is both the issue, but it can also be a solution since advancements and improvements in AI can actually improve the verification process. Demonstration of verifications, it's imperative for responsible authorization of space activities, including the use of autonomous systems and AI, because verification provides the opportunity to avoid significant and preventable harm. Let's talk validation now. So validation ensures the right system is built for the intended purpose. For example, there were automatic trading programs that began operating in an unexpected situation on May 6, 2010. And these systems encountered a situation where their assumptions weren't valid, leading to a so-called $1 trillion flash crash. Fascinating read. The cause of the flash crash basically teaches us that there's got to be assurance that systems will not rely on assumptions that may not always be valid. So validation seeks to ensure that the right system for the expected activities is built, and then to also properly handle situations where the system encounters uncertainty. Likewise, reasonable assurance that space activities, including systems with automation and AI, have been validated to ensure that systems will not rely on faulty assumptions and that they can properly handle uncertainty should be a factor for responsible authorization. And then responsible continuous supervision should probably entail assurance that assumptions remain valid, especially when new or significant information could affect such assumptions and that becomes available. Example of this, I was at a ROCAF space symposium last week. There's Ministry of Defense, ROCAF legal folks, academics, a number of folks there, and one of the academics actually did a presentation. There were 5 presentations. I had one, and I thought it was fascinating to listen to all the other folks go first. The one individual discussed artificial intelligence, and then another individual discussed liability and specifically space debris or space domain awareness and debris mitigation, and how not having proper situational awareness versus having proper situation awareness could affect insurance and also liability, and then some of these obligations of authorization and supervision. So it's interesting that throughout the world we're all thinking of these issues. Control, let's go to control. So that's the third important lesson. And control is the ability for a human operator to monitor the system and change its behavior if necessary. So verification and validation alone may not be enough to prevent an accident, but if you have a human in the loop that can take control of the system, then you've hit an important opportunity there. Because control requires both the ability for effective human-machine communication and then also user-friendly interface. So effective sensors leading to simple warning lights and noises, buzzers, those can contribute to effective communication. Commonly seen today with like lane assist or related automobile technologies. An example of this gone wrong is Air Inter Flight 148's tragic crash in France. And that crash demonstrates really the importance of non-confusing interfaces. So due to the pilot's screen being too small to show the mode that their system was in, when they entered the numbers 3-3 on the plane's keypad intending to descend at a 3.3 degree angle, the autopilot interpreted their command to mean descend at 3,300 feet per minute. And that ended up resulting in the death of all 87 souls on board. So adequate assurance that circumstances warning transfer to human control have been identified as space objects include more autonomous systems and AI will be an important consideration prior to authorization. But also proper planning and capability for timely transfers will be important. And there's got to be an ability for good interface, even if you have this information, so that that human in the loop can react appropriately. That goes back to that first example I started this presentation out with. Continuing supervision should also include reasonable assurance that non-governmental entities maintain adequate control of space objects and ensure proficiency should human operator intervention become necessary. All right, last one. So even where responsible actors validate, verify, and have proper abilities for human control of space objects with AI and autonomous systems, poor security can still lead to foreseeable and preventable mishaps. So we only have to consider all the hackings and the malware incidents occurring on a regular basis to realize the need for security against deliberate threats. Bottom line is cybersecurity should not be an afterthought, and it shouldn't be overlooked. Reasonable safeguards should be a prerequisite for authorization and also for continuing supervision regarding autonomous systems, artificial intelligence. Likewise, it's something that we need to always keep in mind. All right. So one last one, space debris mitigation guidelines. I think this also kind of factors into this technology piece. It's something to think about. So these guidelines, especially guideline 3, these guidelines were researched by technical committees and ultimately endorsed by the UN General Assembly in 2007. The UN General Assembly noted that the guidelines reflected state practice and invited member states to implement the guidelines. It's important to note they're not binding, but guideline 3 does inform prudent design of space objects that use autonomous systems and AI. And specifically, that guideline focuses on limiting the probability of accidental collisions in orbit. So, and there's more about it, but I think that's kind of a good note, and I've included the text of it. So it's, I think that's just an important consideration, certainly for authorization. All right, so let's put technology considerations and state obligations together. So essentially what this all means is that the use of autonomous systems and AI for collision avoidance systems may actually reduce the risk of accidental collisions in orbit, especially when combined with proper control protocols and procedures for humans to change the behavior of space objects when necessary. During the design phase and as a prerequisite for authorization, verification, and validation that software includes the known location and trajectory of space debris and space objects and has been pre-programmed with valid assumptions to avoid collisions would meet the intent of Guideline 3. Additionally, continuing supervision should include verification that systems receive regular updates of newly identified space objects and debris. And the existence and location of all the space debris that could result in an accident or loss of control of the space object is unknown. We know that. We know there's more that we just don't know. But engineering and programming needs to account for how these space objects using autonomous systems and AI are going to address this uncertainty. It's also appropriate for coordination with industry standards. That's going to be an important piece. And I think lastly, the importance of continuing monitoring space objects to allow for a human to take control if and when necessary is going to be a vital part to reducing the risk of avoidable collisions. All right. So now that we've looked at theories of liability, we've talked responsibilities, technology, let's see if we can look at a framework to analyze fault-based liability. And regardless of which theory of liability is used, Hopefully have established or made clear that fault's likely going to be a key element if damage is caused elsewhere than the surface of the earth or aircraft in flight. I'm going to focus on a state's failure to fulfill its obligations, and specifically, I'll talk about the obligations I've been discussing. Although I note that certainly there are plenty of obligations that could be plugged in instead. So here we go with framework. So the articles on state responsibility, I think, are a fantastic starting point. And those articles are a product of nearly 40 years of work to codify state practice and custom on state responsibility. And they reference practice of states, decision of various international courts, tribunals, other bodies, comments and discussion from delegations discussing the articles in the 6th Committee of the UN General Assembly also demonstrate the international community's general acceptance of the articles. Also note that the International Court of Justice found general rule of law on state responsibility as stated in the articles text, so there's a lot of good reasons to rely on these. They aren't binding, and the international consensus, though, is that they do reflect established principles to analyze responsibility and liability for damages resulting from a failure to meet a state's responsibility. So it's a darn good starting point to analyze fault-based liability with regard to space. So Article 1, it recognizes that every international wrongful act of a state entails the international responsibility of that state. And then Article 2 notes that an internationally wrongful act has essentially two elements. And the first is that the action or omission must be attributable to the state. For space activities, typically states are going to be the ones conducting the authorization and supervision through the government agencies, which would satisfy that requirement. And then the second, the action or omission must constitute a breach of the state's international obligation. So recall that international obligations can arise from a treaty, customary international law, or general principle applicable within the international legal order. So as previously identified, states have the obligation to authorize and provide continuing supervision. A state is in breach of its international obligation when its conduct is not in conformity with what is required of it by the international obligation. And lastly, failing to authorize or supervise with due diligence may also breach the international obligation and then constitute a wrongful act entailing international responsibility. So recall under Article 3 of the Liability Convention that the harm state's going to need to prove that its damage is due to a launching state's fault or the fault of persons for whom it's responsible. And states are responsible for their agents, non-state actors, and international organizations they're part of. So the articles on state responsibility help resolve the lack of a specified standard for establishing fault. Essentially, where we get to is fault should be proven when a harm state shows that a responsible state's act or omission breached an international obligation of the state and thereby constitutes a wrongful act. The failure to subject the non-governmental space activities to authorization or continuing supervision, or not doing so with due diligence, fails to conform to international obligations and thereby breaches international obligations for which the breaching state is responsible. And that wrongful act should also naturally constitute fault for purposes of assigning liability if relevant damage occurs. So what are other considerations? Well, assuming fault is required for liability pursuant to Article 7 of the Outer Space Treaty, at least for damage in some circumstances, then establishing fault is going to be the same as doing so under the Liability Convention. So if a harm state can show that a responsible state failed to conform to its international obligation to authorize or supervise a non-governmental entity's space activities, then such conduct constitutes a wrongful act and breaches an international obligation. And then the result is the responsible state's at fault and liable for damage caused by the wrongful act. Now, through a state responsibility theory, that other theory we noted, an internationally wrongful act or omission that breaches an international obligation is an essential element to ultimately establishing liability again, or there. If a harm state seeks recovery through a state responsibility theory, then that harm state should seek to prove that the failure to authorize or failure to supervise was an international obligation, either as a matter of treaty, if the relevant states are party to the treaty, or as a matter of customary international law if the relevant party is not party to the Outer Space Treaty. The harm state should also try to show and establish that the responsible state either failed to authorize, supervise, or use due diligence when doing so for a non-governmental entity space activity. And that violation, again, violates an international obligation and therefore constitutes a wrongful act or omission, which breaches such international obligation. And therefore, you have a responsible state for the wrongful act and then they have an obligation to make full reparation for the injury caused by the internationally wrongful act. So, what other considerations do we have? There's three that I think are worth knowing. First, an objective standard is necessary. States should be responsible for authorizing or supervising their non-governmental entities' space activities unless states know or should know about the activities. So that's consistent with international laws that exist. For example, if you look at Corfu Channel case, the International Court of Justice noted that every state's obligation not to allow knowingly, I highlight that knowingly, its territory to be used for acts contrary to the rights of other states. So when the ICJ used that term knowingly, indicates that states' responsibility for the actions of individuals it's responsible for remains based in fault. And similarly, the state can be responsible for inaction if it fails to take appropriate steps, but under circumstances when the state's aware that such action is needed. So in other words, a state may need to knowingly fail to authorize or provide continuing supervision of its non-governmental entity for the state to be responsible and thereby at fault for actions or omissions of its non-governmental entity. So let me use a simple hypothetical to illustrate why this objective standard is appropriate. So forgive my lack of imagination, but let's assume that Canada has a company called Space Z. And Space Z, this fictitious Canadian non-governmental entity, it procures the launching of a satellite in the Democratic People's Republic of Korea, or the DPRK, at the satellite launching station. And Space Z satellites can provide some kind of commercial uses benefiting Space Z and also the DPRK. So the DPRK fails to authorize a space activity, or they fail to adequately consider its, let's say, its design, its mission profile, other key features and aspects of Space Z's space object. But DPRK wants to retain jurisdiction and control over that satellite and have the object or any of its component parts found beyond DPRK jurisdiction returned to the DPRK in accordance with Article 8 of the Outer Space Treaty. So the DPRK registers the space object consistent with the requirements of the Registration Convention. After Space Z's object is launched, it collides with a satellite of a third state, and a subsequent investigation is able to determine that the crash would have been avoided if the DPRK had only fulfilled its obligation to adequately authorize the space activity of Space Z. And during that investigation, Canada for the first time learns of Space Z's activities in DPRK. So as an equitable matter, even though that Space Z is a non-governmental entity of Canada, Canada should not be responsible for failing to authorize or supervise its non-governmental entity that secretly procures the launching of a space object from another state when through no fault of Canada, it neither had knowledge or any reason to know of Space Z's activity. And additionally, the harmed state is not without recourse from DPRK, because in this case, DPRK is a state that should have properly authorized the space activity of this entity, and it's originating from its territory, and it'd be considered a launching state. Now, the example also causes us to revisit that issue of who the appropriate state is for authorization and supervision. So that previous example, the equitable solution of the appropriate state is the DPRK. In the example, DPRK is a launching state since the launch took place from its territory, and DPRK is the single registering state of the space object. So if there can only be one appropriate state, as some scholars argue, then the DPRK should be the appropriate state given it has likely enjoyed economic benefits from allowing the launch, and it expects continued commercial benefits from the satellite. And it retains jurisdiction and control of the satellite. Basically, as a practical matter, any similarly situated state to the DPRK in this example should not enjoy benefits of space activities without the burden of associated responsibilities. Canada, on the other hand, similarly situated states like Canada, without knowledge or reason to know of one of their own non-governmental entities' space activities in another state, should not and don't have the requisite knowledge to trigger its corresponding international obligations, should not then be held responsible for those obligations. Unlike in the Corfu Channel case, where Albania had knowledge of dangerous mines in its territorial waters and failed to warn the British, Canada had no knowledge whatsoever or reason to know of its non-governmental entities' secret space activities in a foreign state. So if more than one appropriate state's possible, then the obligation to authorize and supervise is incumbent upon all states who know or should know of relevant space activities. Failure to authorize or provide continued supervision of non-governmental entities' space activities can't likely be excused just by claiming that another state's more appropriate. even if every relevant state is deemed an appropriate state. So even if multiple states with a responsibility for a non-governmental entity's space activity arrange for one state to authorize and supervise that space activity, agreement does not divest the other states or state of their responsibility for the obligations. So as a result, states should really be cautious to ensure that if their non-governmental entities' space activities are authorized or supervised by another state, that authorization supervision meets at least minimum standards to comply with international obligations, right? Because an internationally wrongful act also triggers both state responsibility and then the new obligation, international obligation, the responsible state to make reparations for damage caused by the wrongful act. So just a couple more things and then we'll wrap up. So a wrongful act constituting fault that results in damage doesn't necessarily mean that the extent of the responsible state's liability is unlimited. Instead, the extent of liability is directly related to the damage resulting from the wrongful act. So put another way, the reparation should really wipe out the consequences of the wrongful act as far as possible to the condition that existed prior to the act or omission. Okay, so let's talk implications and then then we'll go see if there's any questions. So big picture implications. So just a couple. First, there are numerous gaps and ambiguous, or let's say ambiguities or ambiguous terms. Either way, in international space law, new treaties or additions to the existing treaties are unlikely for a number of reasons. There's not been a lot of appetite for them. But Article 3 of the Outer Space Treaty does specify that states shall carry on their use and exploration of outer space in accordance with international law. And the existing body of international law can illuminate unclear areas and really provide guidance where a specialized body of law does not already. Second, transfers of space objects are going to remain problematic for numerous reasons. One of those is that states can't divest themselves of their status as a launching state. Thus, that saying, once a launching state, always a liable one. Both the Outer Space Treaty and the Liability Convention link liability to the status of a state as a launching state. Practical implication is likely that when a launching state transfers its space object, it can't divest itself of its international obligations associated with being a launching state either. But potentially very hefty indemnification provisions in a transfer, as well as surety bonds may be a prudent way to address some of that, or at least mitigate. And for non-launching states that acquire a space object and fail to provide adequate supervision or fail another international obligation that results in compensable damage, accountability is possible through a state responsibility theory. There's at least a way. And then third, knowledge to trigger obligations, responsibility, and liability just makes sense. States should be accountable only if they know or should know that their international obligations have been triggered and then that the state subsequently fails to uphold an obligation. All right, so just a note, and I think Jeremy noted this in the beginning, but lots of citations, more details forthcoming. I'm incredibly grateful for the help. Certainly, Dr. Harrington at ACS was fantastic helping me with this project and this upcoming article. So with that, I note a quote from Ben Chang at the end or at the bottom here that we just shouldn't forget when we're pursuing special interests like space law to remain fixed to the discipline as a whole, which, as one thing I noted, is international law does provide us a lot to work from to solve some of the questions. With that, I'm happy to take any questions.
Great. Thank you, Maj Sena. I really appreciate your presentation. Very detailed, very thorough, and I think that we all appreciate it. We have had some questions flowing into the chat box here, sir. Obviously, given current events this week, one of the primary questions involves recent activity by the Russians conducting their kinetic kill ASAT satellite test. And so we have a question from Mr. McNeil. How does this apply, this being all of the liability aspects that you've discussed in your presentation, how does this apply to the hundreds of thousands of new pieces of orbital debris resulting from the recent Russian anti-satellite missile test, which significantly increased the risks to astronauts and cosmonauts on the International Space Station, as well as to other human spaceflight activities? Is the Russian government responsible for the damages caused by the debris, for as long as it remains in orbit and during any deorbit.
Yeah, fantastic. So, um, what an interesting, thing to have happen recently. So, um, potentially, right? So, at the end of the day, if there's an international obligation to, or that's been breached by Russia. So, for example, maybe it's that they're not acting with due regard to the other spacefarers' peaceful use and exploration of outer space, or if they're creating some kind of a harmful interference. You think of different potential international obligations that Russia has, and by failing to uphold that obligation, they have committed a wrongful act, and that wrongful act results in damage. Let's say somebody already had a pre-planned launch, and so they were going through this area, and they were, they're unaware that this debris field's cleared, and there's damage created. Yeah, absolutely. There's probably something there, but how far does it go? Because now, it's pretty widely known that this debris cloud exists and the general parameters of it. So, if somebody launches through there, are they kind of accepting, is there approximate cause, so to speak? Are they kind of accepting some of that risk? Those are all unclear issues right now. And I think that's something we'll see. Interesting that, when China had their ASAT test that created all kinds of debris, there wasn't, an immediate objection. But if we have something like that now, maybe even Russia's, are we going to see folks objecting to that based on one of those, due regard type principles, and suggesting that there is a wrongful act? So the short answer is, a good legal answer is it depends. But yeah, it's possible. And as we are learning more about the impacts of debris, of debris clouds, and of what they do in this kind of to other folks' ability to use and explore space peacefully, there's potentially a wrongful act there that could be the basis of of a claim. So, and of course, there's that gets interesting for a lot of reasons, though, because the enforcement mechanisms, the Liability Convention allows for a claims commission. If you're trying to go through the UN, well, of course, Russia has a seat on the council. That gets complicated, and so as a matter of black and white law, there's definitely something there, but is it enforceable? And that's a whole nother issue.
Absolutely. And that was actually a follow-up question by Mr. McNeil, which I believe you answered. He was asking about the actual mechanism, perhaps, for collecting damages in the event of fault, which, of course, as you've explained, right, with the Liability Convention, there is that mechanism written into the treaty, not one that has been frequently used, obviously, almost pretty much never used, but at least theoretic. Some follow-up questions from Ms. Aubrey Davis. First question, are satellites launched after a certain date required to meet any sort of minimum AI parameters, or do those requirements reside with the launching state?
Oh, interesting. Yeah. So I'm not aware of, and I didn't come across any specific, as of December 1st, 2019, satellite shall. But I think we can kind of look almost to, for example, products liability. And I saw some discussion about that, what are the industry standards, right? Because what we know, even in a year, the technology changes can be significant. So the more we know, and the more that something becomes an industry standard, and I think there's a potentially a stronger case to say that there was a lack of compliance. What compliance, or what standards for proper authorization would be for AI based on what we know in 2020, certainly going to be different than what we knew in 2010. So I think that's where that would probably fit in, but I'm not aware of any black and white guidelines now. That being said, domestic legislation has been increasing in a number of states, and that certainly is possible that domestic legislation for authorization may reflect newer standards.
Great, thank you. Second question from Ms. Davis. Is the shortening of a satellite's life to avoid debris, right, possibly through maneuvering, loss of fuel, etc., So the shortening of a satellite's life to avoid debris, is that compensable under the Liability Convention?
So shortening of its life to avoid debris, is that compensable? I guess I would imagine that if somebody's shortening the life of a satellite to avoid debris, I would imagine that's a state doing it to its own satellite. So I don't know that there'd be, I mean, I don't see the wrongful act there. If one state does it to another, so let's say the U.S. says, you know, Russia, that one satellite you have, it's going to create a bunch of debris, so we're gonna, you know, we're gonna shorten its life for you. Well, potentially, I mean, because we're if we're taking some kind of action that they don't consent against their property, I think you might be able to find a wrongful act in there, and and then it's at our fault. But is there, maybe there's something like necessity that there's an argument that it's necessary, because if we didn't take the action, and let's say they had lost control, and they couldn't take action on their own, that if we didn't take action, that it would damage a national security satellite or something of that nature. Maybe there's a way there, and maybe that, arguably that wouldn't be compensable. But I don't know if that answers your question, if I understood the question right, but that's kind of what I was thinking.
I think that, first of all, quick aside, since I have been reading through the rest of the Q&A block, Mr. Davis, my apologies, Mr. Aubrey Davis, and he says that it did answer his question. Thank you. Awesome. Okay, great. Our next question is from Aaron Johnson. Everything you've discussed is about state responsibility, but as you've mentioned, non-governmental space activities are increasingly rapid. Do you foresee, or does international law address or have some way to address situations where two private actors might try and use existing domestic law to resolve liability for space accidents? And gives an example, what if Amazon and SpaceX collide in space, pieces fall onto Elon Musk's barge? That seems like it could be addressed in US courts. What about if Canada's Space Z is in an accident?
Sure. Yeah, so the Liability Convention actually does have some discussion about it, but bottom line is domestic remedies can be sought. Now, of course, if you have two different states, and one state's trying to resolve it in their own domestic courts, would the other company agree to that? Different issue, but I mean, it's possible. Yeah, can states resolve things domestically? Sure. So that's an option, or I should say, not private actors. Can they, let's say Space Z in Canada and SpaceX in the US, and they decide to resolve it in Canadian or US courts? That is possible, absolutely. And the Liability Convention even does contemplate that. As far as difference, bringing in accidents, of course, a lot of that is going to be, is there jurisdiction? Jurisdictional issues will be a piece, and whether there's all the jurisdictional pieces and consent and those kind of things when you're talking about different sovereigns involved.
Having not seen any additional questions flow in, I will once again thank you, Major Sena, for your time this morning. We really, really appreciate your presentation. Fascinating topic, and definitely looking forward to the publication of your paper. Sir, do you have any final thoughts before we let you go this morning?
Just, yeah, the one thing I really took away is I was, like I said, just fascinated last week. Got to be at that ROCAF Space Symposium, and all over the world, we're having these same discussions. So it's fantastic. I'm incredibly grateful that you've created this for us to have these discussions, to be thinking about this, because it's not too early. Like I said, I don't know that we're gonna have billboards in space that say, call me space, or something like that, too soon. But all these issues very much are important, as we're all talking about commercial, civil, and military partnerships, and working with our allies. And we know that these issues are not far away. But we also know that as we think about them now, a lot of informed decisions can be made, and we can really add a lot of value from the legal community to our space activity. And so it's really neat opportunity. I'm grateful to you and to everybody who's listening. I very much hope this is helpful, and I'm happy to assist in any way if folks have questions offline.